Call to order the meeting of the Family Court Subcommittee of the Children and Family Law Committee. For the record, I am Subcommittee Chairman Mark Pearson. I also chair DHHS Oversight, so if you wish to call me Mr. Chairman, that would be both appropriate and appreciated. The secretary is Representative Raymond, and we were discussing earlier what kind of minutes we should have, and I just suggested write down what we are discussing so that later we can pull that together when we come to conclusions. A subcommittee is a bit more informal. I see the minute taking akin to the DHHS Oversight Committee, where when the next meeting rolls around, we look at the minutes and realize what we had actually talked about. Later on, we will be forming some subcommittees of this subcommittee, and those will be noted in the record as well. This subcommittee wishes to continue the good work of the special committee on the Family Division of the Circuit Court of the State of New Hampshire, which met for the entire 2 years of the last session. We had 5 members from Children and Family Law, 5 members from the Judiciary Committee. We divided it intentionally 5 and 5, Democrats and Republicans. We tried to set a tone of collaboration with the judiciary. Some people don't think that being cooperative with the various bureaus and agencies and divisions of government is a good idea. I would point out to them that is why in the past nothing ever got done. We got stuff done because we ganged up against problems. In fact, we never voted on anything in the 2 years of that special committee because we didn't have to. We worked for consensus within ourselves and with the judiciary, and we kept working. As a result, we got to pick some low-hanging fruit. And already we are seeing good results of those entry-level changes that were made. Attorney Cregan recently gave me a report on how they are now playing out because, hey, if we did something, we'd like to see how it is happening so that we can say to the public, yes, changes are being made, not just in theory, but in actuality. You've asked for certain things. Here's how they are taking place. And I'm hoping you can give me a further expert opinion on further implementation down the road. I think that was a nod yes, or a giggle. Yes, I'll take either. We set a tone of collaboration, as I said, and that meant that going into this term, we are working well. We will be working well. The 7 members of this subcommittee are all drawn from Children and Family Law. It breaks down 5 Republicans, 2 Democrats, because they were the 7 that I could catch when I was out looking for who wanted to be part of it. I have a very strong feeling that partisanship will not matter, as it didn't last time. We are running together for one end zone, and that is doing good things for the state of New Hampshire and its people. We took 12 hours of testimony last time. A percentage of those people came for the purpose of persuading us to retry the cases which they lost. By law, we cannot do that. Another percentage came, in part at least, to accuse an individual judge or all judges. That latter part tended to discredit anything else that they said. All judges are not lazy. All judges are not corrupt. And if there is something specific against a judge, there is a proper channel of complaints. That group does receive complaints, and that group has acted in the past. But a few people came to give us what was helpful information on process. They made some suggestions in terms of admission or inadmissibility of rules of evidence, for example. They made some suggestions on communication between criminal and civil cases in different jurisdictions. So there was some helpful information that came to us. And what it wound up doing is showing us where we need to do the work. Therefore, I don't have any plans to call on public testimony. We've heard public testimony, and where it was useful, we've taken it. We know pretty much what our project will be. Now, we will gain input in our work from a number of sources. From the testimony previously provided and Attorney Grant, our researcher, you will have access to the testimonies from the special committee of last term. And as needed, as you filter through it, this is what you will do when you shouldn't be playing tennis. Okay, if you see a few things that look helpful, just photocopy it off for us. A lot of it, as I said, people came, people were in pain, but in spite of instructions, they continued to try to have us retry cases or believe all judges were corrupt. Where you find helpful suggestions from the public, we want to hear those, okay? Second source of input for us will be Representative Bernardi's bill. And in case you don't have a copy, you are about to. And if you could hold one for Kim. And let's see, a couple more. And one for the file as well. Our job as a subcommittee is the overlapping of two different things. Number one, House Bill 652 is retained, and we will need to comment on it. Our second purpose of the subcommittee is, irrespective of House Bill 652, what additional changes do we want to work towards in family court? 652 is quite lengthy and quite detailed. And especially when it gets to mediation and the Office of Family Mediation, which is suggested, there's a lot of stuff in here. And my attitude towards the bill is I want to go where our work together leads. And in some cases, it may be line for line what this bill is saying. In some cases, we may go in a different direction. But I'm approaching this bill both with an open mind and as a resource. In addition, you have already been handed out a lot of stuff. And some of this has to do with what other states are doing. Some of this has to do with what was recommended back to the early days when the family division was stood up as a separate entity. You can always get more information. If in the subcommittees that you are working on, you think you need more information, you can always go to OLS and ask to speak to one of their researchers. That's open to anybody in the legislature. But it's usually through the committee or subcommittee chair that committee services and Attorney Grant are asked. You don't call on your own if you want to suggest an amendment to a bill. You come through the committee chair. My attitude on this is, since we're going to have a number of subcommittees, I would rather turn the members here loose to call you on the very specific thing of we need more information on this. Nothing else but on that. I think we can eliminate the middleman on that. Say again? Okay, yeah, permission. What do other states do? Fascinating reading. What was recommended in the past. I've found a few things that every past report recommended judiciary do, and we may agree and they might just do it. I found some things where, as the court continued to function, the next report thought maybe we better back off on something. So there's a lot of information, is my point. We want to divide the work. I see the work as coming under two major headings. Number one, what happens before the trial? And Representative Gregg has in her computer, and I'll ask her to read in a minute, some of those subcategories. This is an email that you all received and I forgot to print out. What happens before trial? How can we help the two litigants come to an agreement so that court is not necessary? What are the qualifications of the people that help them do this? Who are the supervisors of this? Should there be additional elements? A few states actually bring in counseling. A part of the problem that's causing them to go to court is one or both parties have PTSD. How can that be addressed? Because no amount of signing a paper, it just means we agree how to get a divorce. Is there a way that the problem or the principal problem itself could be addressed? A few states are looking at that. So pre-trial. And then the trial itself. Should there be a separate family division? What do other states do? Why was this established in the first place some decades ago? Should there be distinct family court judges who do nothing else? They do not do probate. They do not do other issues. Should they be dedicated judges? What should their training be? How broad should it be? There have been times when, sometimes to me at least, family court looks like it's neither fish nor fowl. What should we do? What should we do with domestic violence issues that are in one court, but the divorce is in another court? Sometimes those two judges are not communicating. And I think there's procedural problems more than there is either anger or laziness on the part of the judges. But so what should family court look like if there should be a family court? How should we change it? What should the rules of evidence be? What documents should be given to the litigants to help them as pro se litigants? So those are the two broad areas that I would like us to attack. Now, probably the best way to do it, in my opinion, is to divide each one of those two broad areas into subcategories. I'm told that if we have two people officially named to do it, this will not be a 91A violation. We have 16 people in children and family law. We have 7 people in this subcommittee. If we have 2, this is not a 91A. You can meet when you want, where you want, how you want, and you will be free to ask people to come appear before you. You will be free to get documents from other states, from our own state. You'll be free to talk to judges. You'll be free to go on road trips. You'll be free to do all of these things, but work on your own. Others may informally wish to adhere to you. They won't be officially named, but they'll ask, can they hang out with you? And the two of you may say yes, in which case they're not official members, but they might be regular visitors with your leave of them to do it. So we are not going out of the 91A situation. That way, we can work over the summer. We don't have to be in this building. You're free to discuss things openly and so on. That's what I'm suggesting. Any feedback, input, suggestions on this so far? Representative Raymond.
Thank you. Thank you, Mr. Chairman. Oh, I don't think it's on. I'll just be loud. So does this building is closing shortly, correct? So if a subgroup wanted to elicit feedback from people, is there another place that is available to the members of the subgroup, or would we have to like set up at like a coffee shop?
Do you mean the subgroup of 7 or
The subgroup of the
2?
ones you were just talking about, of
Yeah,
2 people who were
it's Tandy's.
researching.
It's over there. They serve beer. You can meet anywhere you want. It
Okay.
is not a public meeting.
Oh, okay. So it wouldn't be
Sure.
broadcast.
Have a pool party and invite 2 judges.
Here, I'll put it on here. So I think that we all have a great list of like emails that we've heard from. So what that means is we're free to reach out to anyone that has, given input and stuff to ask them directly more information.
With Attorney Grant plowing through the testimony from the special committee and coming up with a few testimonies that, hey, this was helpful, you could certainly ask that person to come to your group of 2. Madam Chairman, DeSimone.
Thank you, Mr. Chairman. There are also rooms at the State House that might be available if you wanted a central location. You would just have to clear it through leadership on whether it be majority or minority, clear it through them and see if there is a particular room available for a very small meeting. That would make it easier for, it might make it easier for judges, department heads, experts in the field, whatever, to meet in a central location. So that might work too.
I would think theoretically, if you had a particular judge you wanted to speak with, that judge might invite you to her or his chambers, and you're there, the 2 of you, or 2 plus friends. Attorney Grant, does that fit with what Attorney Cianci had said to you? All right, I can't. Could you come up to the nearest mic, please? All right, because we had discussed earlier the parameters, and I'm trying to keep within those, certainly. We might want to find out, what if 2 of the groups of 2 discover in some areas their work is overlapping, and wouldn't it be nice for them to meet together as a group of 4? Well, now we're starting to get into public meeting, and we'd need to see how we do that. We want to do this kosher, okay? Yeah. Sure. Okay, thank you. Anything else about my guess on how we should proceed? Divvy the work? All right, let's, Representative Gregg, would you please read from the memo what were some of the suggested things for pretrial?
So you have listed before the trial. First one is alternative dispute resolutions that exist in some states. It says that you have materials, are not sure where you got them from. Attorney Grant will make them available. So that's number 1. 2, mediation. And what is the training and supervision for mediation enablers? What are we doing now? What does Representative Bernardi propose? What do other states do? 3 is counseling and therapy. What if one or both parties suffer from PTSD and with counseling could find relief? Might that help resolve problems bringing them to court in some cases? What do other states do? And then 4, materials developed by the New Hampshire Bar Association as to how pro se trials are conducted. If litigants read these materials before going to trial, it may impact their decision on whether or how to proceed. And then you've had conversations with New Hampshire Bar as to how to better inform litigants, maybe one other person to assist you in this.
Anybody think of any others? Representative Bernardi, do you think of any? Because, you're the guy on 652. Do you see any other issues that are pre-trial that we may want to consider? No? Okay. And that would cover actually all of these things. Okay, that's good to know. Attorney Cregan? Any thoughts about pre-trial topics that we should consider?
I don't have any suggestions, but I'm happy to help you with anything that I can when you're looking into it. But in terms of something to consider, I'm sorry, I don't have anything else to add.
What do the courts in Thailand do?
Oh,
You were just a tourist, I know.
I should know that, but I don't. I'm
Okay.
sorry.
Thank you. Okay. Anybody on the subcommittee think of anything we should look at pre-trial? As we plow through the literature, there may be something that actually suggests itself. All right. Yes, Representative Chairwoman.
Thank you,
Buddy.
Mr. Chairman. My thoughts when it comes to pretrial is hearing some of the very legitimate complaints of pro se litigants. I think when a trial is coming up, it might be easier if there was some sort of a pamphlet or discussion with the pro se person as to the rules of evidence, the rules of testimony, things of that sort, to help that person be able to prepare better and understand better what is going to happen to them, to give them, for the want of a better phrase, a fair fight. They don't go into these trials as an attorney would, or a mediator would, or a marital master would, understanding the constraints that they have to follow and the rules that are going to be expected of them. They're just plain ordinary people trying to do what they believe is the right thing for their family. So I think that might be helpful to investigate something like that. I'm sure there is literature already, and I know that there's a huge packet that's given to people, and I don't know if maybe the rules of evidence and all of that stuff shouldn't be in there. So that's my suggestion.
It's a great book.
It is.
Actually, that is the topic number 4, the materials by the New Hampshire Bar. That wonderfully expands the process of what we hope to do. And I just jotted down here, that would be an occasion to go to former litigants and ask them specifically, what do you wish you knew beforehand? And then maybe even co-opt them into the process of helping to design some materials. Representative Gregg.
Thank you, Mr. Chairman. So the forms is actually something that one of my subcommittees off the special committee handled. And I know that the courts at that point were working to, we actually showed kind of how clunky the site was as soon as we got on. So they've been working to correct that. I'm not sure if they're there yet, but that is already something that we did address. I think a lot of this seems like a redress from what we've done without giving a whole lot of time to see what the courts, how they're implementing these as far as communication, as far as the records and stuff. So I just want to make sure that we're being realistic as far as we did have some of these conversations and what the courts are doing with them. And maybe that's just something that we redress and say, where are you guys with that process? Because they certainly saw that the website was a little clunkier than they liked, and that the forms, they were going to do something a little more. I mean, we can't give everybody a law school degree that's going to go in there, but certainly that it was, more explanatory and in other languages and stuff. So I want to make sure that we're not, that we don't focus on something that we already had a partial resolution and it's just not had time to come to light.
I would see those things as parallel, the forms, but then also how do I do the process? Those are two different things, but they are very related, and so they could couple. But your point is well taken. In her next update, we'll find out. I remember you were so ahead of the game on this, or you were, and I think you both were wonderfully together, collaboratively, of course. And there was a request for proposal actually going out. So we'll get an update on that pretty soon. And yeah, we don't want to undo all that good work, but we want to make it in parallel with other things people will need. Okay, those are the pre-trial items. As I say, we may find a few more suggest themselves. Okay, what's on the list for the trial itself?
See, so during the trial, you have additional training for family court judges. What do other states do? And then part 2, issue of judges dedicated solely to family court. How better to make sure one judge stays with one case. And then 3, intersection of civil and criminal. Domestic violence issues heard by the same judge as marital issues, a good idea. What do other states do? Oh.
Anybody else have anything to add to this list? Yes, Representative Raymond.
Thank you, Mr. Chairman. I have a question, and I apologize because I missed the last meeting because I had pneumonia, which was not fun. In some of our hearings at Child and Family Law, and I know that the special committee previously had discussed it, people were concerned about during the trial, judges' behavior as it pertains to recordings, as it pertains to documenting different things that were happening in the courtroom. Is that something changes have been initiated, or is that something that we're still looking for a little bit more information on? And I know we've seen a couple bills too about,
Good morning, Erin Cregan, General Counsel for the court system. We haven't had a change to the recording technology that we use in circuit. There is a difference between Superior, which has court monitors, which are people who are specifically tasked with preserving the record and making sure that the recording is going. And we just don't have that staffing in the circuit court. So there's not a court monitor that's staffed to each proceeding. So very often it is the court security officer, who may be the only other person in the room with the judge, turning it on as the judge comes on the bench, and then hushing it so that people can have private conversations with their attorney when the judge is off the bench, and then turning it back on when the judge comes back. So that is a much less staffed operation in circuit court and Superior. We haven't had a change to the staffing or the technology there, but I do think that there are ways, if a person were concerned, that they could look in if they thought it was cut or not. And I think I'd suggested some of the different ways that they could check. You'll generally see if it's not recording, the time clock will go blank. That'll mean it's not recording. It'll tell you. So you'd be able to kind of see that that's where the recording is cut off at that point. And then you just see, for example, on video surveillance, people talking in the court, but the judge is not there and the time clock is not on. So we're certainly open to making improvements. But of course, this is a very tough resources year. It's just something we've not been able to resource the circuit court in the same way the Superior Court is with staffing for recording.
Any other questions that are possible topics during the trial? I don't know how I left this one off, but rules of evidence. I see different ways of this being handled in different states. And we have heard numbers of objections, which interestingly sometimes canceled each other out. Some people wanted any proffered piece of evidence automatically to be accepted with no restrictions. One of these persons also wanted trials to go faster. I tried in vain to point out that it had to be one or the other. It could not be both. Others do not understand that non-probative proffers should not be allowed. They're not relevant particularly, and you particularly don't want them when they're coming at you. So there were numbers of different issues that were raised on rules of evidence. I'm open to whether this is a topic we may want to consider at this point or do it later or not. I'll just put it on the list, and if we get a couple of people signing up for it, then we'll go with it. But anything else?
I would like to discuss one thing.
Yes.
One of the things that has plagued many, again, pro se litigants is the cost of retrieving transcripts of their trials. It can be very costly. And for many litigants, it's just not financially prudent for them to be spending their money on that instead of their families. So it has always concerned me that you're paying court costs, yet if you want a transcript, you have to pay more money. I'm wondering if we can work somehow with the courts to find a way to not be charging litigants such hefty fees for obtaining a transcript of their trial. Not everybody wants one, but yeah, please.
Thank you very much. I just wanted to mention that sometimes folks think that we have prepared the transcript ourselves and it's available, but we don't have that staff. We don't have transcribing staff. There used to be court reporters in the court system that were kind of taking those contemporaneous notes, and we no longer have court reporters of that type in the court system. So the service that we offer is that people can ask a private company to transcribe it for them. So they're paying those bills to that private company to get a transcription service. So it's not as though we have the records and we're just, giving them at a very high price. That's the cost for the company to do that service. And it's sort of the New Hampshire way in a way. We're trying to kind of move things out of having a large, government overhead and a large number of employees that are doing things to kind of more of a fee for service model. So there'd be many ways to kind of solve that problem, but I think it would either be that the state would assume some of those costs of private transcription, or the state would want to have more employees doing that kind of work. And I'm not sure what there may be even other options I'm not thinking of, but that's part of how it's come to the situation it is now, which is to sort of reduce overhead within the courts and move services into the private sector that people can pay for when they want to consume them.
Follow up.
Devil's advocate here, it's not the litigant's choice that the state outsources. I get why the state does that. That's an okay thing. Again, the litigants are paying court costs, and if the courts choose to outsource, then I think that we might be able to, maybe we can't, but we might be able to work some sort of a compromise, like you just alluded to, that somehow or another we make it easier for these people to have access, even if, I don't know, there's like a million things going on in my head, but I'm wondering if we could try to just help our constituents to be able to have access at a more affordable standard. So yeah.
Absolutely. And if it's something you want to study, and if there is a state that is able to find a good hybrid model that's great on costs, and we don't know, we definitely want to know and be doing things in a better way. So I appreciate your interest in the issue. I just wanted to make sure that you had the sort of baseline information.
I get it. Yeah.
In this case, the judiciary seems to be a microcosm of the budget process. There are so many very needy causes and so much money within the spectrum of the governor, the Senate, and the House. There's still a limited amount of money, and more than that in terms of causes different groups champion. So if you're going to spend some of your court cost money on this, you would not be spending it on something you presently are.
The current draft of the budget is a 7% cut to the court's operating budget. We will be closing courthouses. We will be canceling jury trials. It is a very ambitious project. The courts generally complete cases on average for $900 each. So, and we are less than 1% of the state government's budget. So we certainly want to be as efficient as possible and as responsible as we possibly can be with state taxpayer dollars. But sometimes we simply run into a limit of the services that we can offer on the budget.
Seems to me the people who came in here for 2 years talking about too long a delay to the next hearing will look at those as the good old days.
The legislature has worked so hard filling judgeships, doing so much work to really reduce that backlog. It will be heartbreaking for people to tell us that we've returned to that level of wait times for court time when there has been so much collaboration between our branches trying to bring those times down. I really hope that doesn't happen. I know many jurists are personally committed to making sure that doesn't happen, but none of us wants someone to wait 2 years for a divorce. That's just not a positive outcome for anyone. So I hope that doesn't happen.
Thank you. Representative Gregg.
Thank you, Mr. Chairman. And if I could just take a minute, we hear a lot of obviously complaints. It's always easier to complain than to say good things, especially in our committee. But I actually went back through, once we heard that they have 22,000 cases a year in the family courts, I went back through and I added every person individually, not that they've come back multiple times, but every person that's come in here and complained, whether it be the special committee on DCYF even, because that included some of the courts, all this. And then I tripled, that number just because I'm like, well, maybe I'm missing somebody. So when we're looking at less than 0.5% of what the courts see. So I want to keep that in mind. There are certainly cases where we have seen hiccups. We have seen things that maybe could be a little bit smoother, but we do understand the New Hampshire way of keeping our budgets incredibly tight and understanding what the judiciary is in, and also understanding that anytime somebody has to go into family court and you have to have the court system get involved in your family, not too many people are going to be super happy, regardless of what's going on, because that's such a high emotion time in a lot of different ways. The ideal, of course, is if we could all just get along, but that obviously doesn't work because we each have our own thing. So I just want to keep that in mind as we look. I think certainly we will have hiccups, but we are not seeing a majority of people coming in complaining. We are looking at most, and I tripled the numbers I found, less than 0.5%. So that's just really important to keep in mind. We don't want to also upheave an entire process for less than 0.5%. So thank you.
Thank you. I just looked down this list and it evidences a bias. And then remember, I wrote the list initially. It evidenced the bias of there being a family court. And that begs the question. So I've just added to the list should we have a family division or not? It is what House Bill 652 looks at. Should we go back to the way it was 30 years ago? What do other states do? If we do, what should change? Because we know there's some changes that need to be made. If it is stood down and goes to Superior Court, what would have to take place then for that to be the court of jurisdiction? So we'll add that one to the list. All right. Anything else in terms of divvying up the work? Now let's see who wants in on what. You can certainly pick more than one. I want to have two people to be assigned so I will know that we have a discussion, although we probably all talk to ourselves. If others say, gee, I might like to hang around sometimes, that's fine, but you won't be appointed, but it'll be noted. So the pretrial issues, to look at the question of alternative dispute resolution, which I think is an informal trial, as I remember reading the stack. Counselor, is that correct? Are you familiar with other states?
Yes, I am. And ADR can be a very effective tool
Okay.
if depending on the circumstances.
Okay, so then there is such a thing, and that's what it does, and it's happening some places. The current kind of mediation as being looked at by 652, what are the qualifications of someone to be a mediator? What training do they get and from whom? Are they supervised, and if so, by whom? The whole question of mediation as it currently generally exists, that's number two. Should we look at the issue of counseling and therapy? And that certainly could be outsourced, but it would be intentionally outsourced as opposed to just being assumed or hoped for. And then materials that the New Hampshire Bar will help for litigants on how to prepare testimony, how to prepare better for trial, rules of evidence, how does the court work, all of those, how to do the stuffs, plus the forms. So those are the four, and who would like to be involved in looking at alternative dispute resolution?
I have a question. Since there are only 7 of us on this committee, are you thinking about having people combine some of these subcategories? Because as I'm counting them, there's more than 7 subcategories.
Oh, you know that. No, I'm not, because then we get into the whole 91A question about can we work over the summer and all of that. What I'm thinking of, if any of these topics is undersubscribed, we'll wait 6 months. I mean, I hope this subcommittee will last for the biennium. So we may wind up picking it up at a later date.
Okay.
So I don't expect one person to be on more than a few of these, and I do expect more than one of these topics not to be worked on right away. So take a look at the list for pretrial.
Well, Mr. Chairman, I for one am interested in learning more about what other states do regarding alternative dispute resolution, because that's not something I have a
Okay,
great
we'll put your
degree of
name
interest,
down.
knowledge about, but I do have interest.
It's in this stack here somewhere.
Yeah, I made it into a binder, and it filled up a whole binder, but it's heavy, so I didn't bring it with me.
So Representative Raymond, alternative dispute resolution, while we're with you, any of the other 3, or would you like us to come back to you?
You can come back to me. I mean, I'm interested. I think that mediation is an alternative dispute
That's what I was just
resolution.
getting ready to
so like
say.
I feel like
I'd
those
like
two
to take
kind of
both
go
of those 'cause
together.
I feel like they kind of go together.
Would you, is it different enough for mediation to require two discrete committees, or should it be combined? Combined?
I think that we could combine that because I actually think that it is hand in hand, and we're getting agreement from the courts here. So
Okay.
All right. So yes, I would like both of those. Thank you.
All right. And so Raymond and Greg, last time somebody said to me, you had 3 Democrats and no Republicans on that subcommittee. And I said, your point being?
Well, for all due respect to all other committees, this committee is different and we usually
Yeah.
don't have an issue. with
Yeah.
that.
It never became an issue.
Yeah,
We ganged up against problems, and the fact it was all from one party didn't really make any difference. And I don't see it well going forward on this.
even in child and family law, I think out of the 33 bills we had in front of us, we agreed on like 20 or 29 of them.
Yeah,
Yeah.
I mean, we are not
Yeah.
typically a partisan group.
no, we,
Gang up against problems, not each other. Yeah.
and there are certain things working in the summer. Representative Raymond and I are actually in the same district, area, so it makes sense for us to be able to work
You can meet
together
at the cross street.
in Nashua. Yeah.
Yeah.
So it makes sense. Yeah.
All right, next one is materials by, going out of order, materials by the New Hampshire Bar Association for litigants, the how to do the stuff in court, plus the forms. Would you like to work with me on that one?
Yeah, I'll do that because we've already we have some process already going on that. So
And I'm already working on the part with the New Hampshire Bar.
okay,
So,
great.
So I guess we meet in Wyndham.
But did Representative Nelson want to be on that? Because I can,
Did you want to be on that as a hanger-inner, outer?
I can come off of it if you wanted to do that one. Oh, then go for it. That's fine. Just as long as we're checking in with what we did on the special committee, because we've done some work on that. Yeah.
Well, why don't we put Greg and Ray be named, and I can be this sort of guy in the shadows?
okay.
What's that?
Greg and Nelson,
Nelson.
right, Chairman?
Welcome. But at least it was a member of the committee that Steve, welcome. All right, now, question of counseling, therapy, an intentional sending of one or both parties, or highly recommending for issues that would impact. Anybody want to take a stab at that?
I was just asking Representative Markell if he'd like to work with me on that. We're in the same district, and so that might. Sorry, which one was that?
The counseling therapy issue, a few states have it. All right, so we've got the pre-trial of alternative dispute resolution / mediation training supervision, Raymond and Greg, counseling therapy, Markell and DeSimone, and the materials by the New Hampshire Bar to help pro se litigants with the forms and how that enhances things. Greg and Nelson with me in lurking in the shadows. Trial. Should we have a family court or not? Training, if we do, the training for family court judges, the sole dedication of said judges to family court. Actually, those two might be combined, you think? Does
Yeah.
think that makes sense? Yeah, okay. The intersection of two different courts. All right, the intersection of two different courts, alrighty. Whole question of rules of evidence. Boy, that better be me. And
You're going to serve with Representative Gray on the actual trial.
okay,
Is that what you're saying?
no,
Okay.
no, I'm not.
On the intersection of civil and criminal, would it be okay if I asked Representative Rice if she would be willing to do that one with me,
It
if
would
nobody
be
else?
wonderful to do
Because
that.
we're kind of in the same
Yeah,
area too, and
report
that would
back.
make sense.
Yeah, report
Okay.
back.
And I know she has a great bit of knowledge in that area.
Yes, she does, and the fluidity of when you meet would be very convenient to her. All right, so we've got that one to be asked. Anybody want to tackle rule of evidence with me? It's fun. It's got a nice book.
Representative Markel wants to do that.
Okay.
Rules of evidence, Markel.
The cost of retrieving transcripts. You will do that. You know, that would be Representative Nelson who
I'd
just
like to
said,
work with her on that.
okay, DeSimone. We are left with, should we have a family division of the court or not? And then, and the training, if we do the training and sole dedication to family court, which has come up in every report on the family court since day one. And I know they're trying to do it, but what if you're down a judge? It's like, you know, schedulers everywhere face this kind of thing. So should we have a family division or not?
I can serve.
Okay.
I feel like that's one that we would, after we do kind of all this other stuff and we understand more, like, you know, we on that special committee, we went to the courts, we saw what was happening. I don't think that kind of knowledge can be replaced, especially I know that Representative Markel has been in the courts, but it's a different thing to go and observe cases. But I think that's something that we should all try to kind of observe, and maybe we come back together after all these other things and discuss that. I think that's a big, you know, subcommittee discussion that's not a split. I think after we've all learned our things and shared our knowledge, that's more of a endpoint discussion based on what we find.
I agree. I think that the final, should we have a family court subject, should be the entire committee, not a sub-sub.
Okay.
Should be the entire subcommittee.
I think
And
that's
then
right.
We can bring it back. So that would be all 7 of us. Yeah, thank you. I agree.
And I did get confirmation from Representative Rice that she would be on that discussion with me on the intersection of civil and criminal. So she's signed up for that.
Wonderful. Thank you. So the last one is assuming, well, maybe assuming there is a family court, but the same thing could be said for Superior Court justices if they're going to hear family cases now. What should the training be? I have discovered some states have significantly more training than New Hampshire does. And the question is always, every hour you've pulled them out of court for training, you know, you got the problem of more cases, fewer judge time. On the other hand, the more training you have, the less likely you are to make mistakes. Used to be the case that you graduated medical school and you had 1 year of internship. Now it's 3 or 4 before you even get into fellowships and subspecialties. It has been noted that the mistake rate has gone down. So there is something to be said for don't necessarily work harder, but work better. And this is how we can do it. So the question of training, what does the training programs look like? What do other states do? How could one better have one case, one judge? I don't know the answer to that. So that's the last one that has not been assigned yet. And anyone want to bite on that, or is that something to defer? Because let me just advocate for perhaps one side. Arguably, the training of family court judges would be different than the training of Superior Court judges who sometimes happen to hear family cases, one would guess. So maybe we should defer that until the question of should we have family division or not is looked at. Representative Gregg.
I think that's a good idea. And we've had bills, I think about the bills that members of our committee have put forward. And one of them was on, judicial training and wanting more in the area of domestic violence and those kind of specific things. So we have certainly found areas before where we're like, we feel like this is lacking, but unfortunately those bills have been stopped for one reason or another. So we do know that there's probably some lacking areas, but I think once again, this is a consensus thing once we kind of do the research and really look at what's going on. So everybody on this committee can kind of understand what we were able to on the special committee last time.
So let me read the list once again so we have it all. Pretrial, the question of alternative dispute resolution / mediation, mediators training and supervision is Raymond and Gregg. The idea of counseling and therapy, Representatives Markell and DeSimone. The question of materials by the New Hampshire Bar for pro se litigants, and an ongoing watching the improvement of the forms that have to be filled out. Representatives Gregg and Nelson with Pearson as a lurker. During the trial, the intersection between domestic violence and the marital issues, which is often two different kinds of courts. Gregg and Rice. Rules of evidence, Markell and Pearson. Cost of retrieving transcripts from their trials on top of court costs, Nelson and DeSimone. We will defer the question of should we have a family court or not. We will defer the question of training of family court judges till later. One I missed, during the trial recordings, it's different in Superior Court. There is a person tasked. In civil court, it's sort of catch as catch can. Does anybody want to handle that one? Or could we argue it begs the question, if we have family court, it becomes a live question. If we recommend the elimination of family court, it becomes moot. What do you think?
Well, I'm thinking that with Representative Nelson, we can actually look into that while we're discussing the whole transcripts issue.
Okay, so combine that with transcripts then?
I would, are you okay with that, Representative Nelson?
Yes, I was thinking the same thing.
Great.
So can you read that title again to me?
Well, it's sort of a loping
That's okay.
title.
What did it say?
The subcommittee of Nelson and DeSimone will look at the cost for retrieving of transcripts of trials and who and to what degree should pay, and the question of during the trial itself, the recordings where Superior Court has a person tasked with this, and civil court, it happens as it happens. So that's that can be boiled down to a better phrase, but that's the gist of it. Yeah,
I
yeah,
get
that's
you,
good.
and I think that it makes sense to combine those two. Yeah. So I'm happy to work with Representative Nelson on that.
Me too.
You're happy to work with Representative Nelson?
She is.
Good.
She likes working with Representative Nelson. They like each other a lot.
I've heard. When you talk to yourself, is that a committee meeting? So Attorney Grant will be very happy to consult with you, as will Attorney Cregan. And on any of these things, when you're looking for what other states do and what we have done or recommended we do in the past here in New Hampshire, we hope that relevant information from those in the 12 hours of public hearing will be disseminated to the relevant subcommittees. And gosh, you're free to call judges, and I've got a list of everyone in the New Hampshire House and Senate with a JD, and I'm starting to call them and just saying, hey, here's what we're doing. What do you want to tell us?
I just have a question. Senator Gregg, what county are you in? Hillsborough. And Representative Raymond, you're in Hillsborough too?
In the same
Okay,
town.
so we may want to, just out of curiosity, talk to some of the county prosecutors and see where they are with that kind of thing. Just out of curiosity.
Yeah, and I think it's interesting to find out if there's any differences between Hillsborough and Rockingham, or even Hillsborough North and Hillsborough South,
Yeah,
right?
I agree.
that was my thought process.
Yeah.
Yeah, I think, that's one thing. Even in Nashua, we have, our different wards, and each ward has its own kind of unique thing. So I think when we look at our courts, it's helpful to look at that. Like I came up to Concord on the special committee. I was already familiar with that, but I just can't stress enough how important it is to go in there and actually observe and kind of see what's happening. Like that underline the fact that we needed GAL for me, that we needed to try to provide that for people who can't afford it, because we saw it over and over again. But it is interesting to go into cases, see both sides in there about what's going on, not just one side that has the ability to come talk to us, but it really is a great value to just go in there and as an observer and kind of see what's happening.
Before I call on the clerk of the House, I've got another printout. This is for everybody, but it is particularly for Representatives Raymond and Gregg because it has to do with family mediators and the substance of their training. So everybody take one because we'll all be dealing with it eventually, but it is especially for that subcommittee. And one for the file. And there we are. Now, the question of 91A has been appropriately raised, and I gave a tentative policy based on what I thought I knew, but the clerk of the House is here and maybe can officially tell us what we are and are not allowed to do, if you wish. He does not wish. Yeah, please sit at the microphone. Children and Family Law Committee is 16 members.
Correct?
This subcommittee is 7. I've just appointed subcommittees of 2 to work on discrete topics. And it would seem to me that when they meet together to discuss, it would not be a public meeting that needs to be noticed in the calendar and held in this room or its surrogates, but they may discuss and go where they wish. Is that correct?
I would feel better if we had a conversation with the House Legal Counsel about this. I would suggest to you that 2 members of a subcommittee is not a quorum in terms of official meeting purposes. However, I am loath to giving you advice without the benefit of any discussion.
Attorney Grant, would it be possible to call the 4th floor and see if Attorney Cianci could come here now?
Mr. Chairman, I'm not sure we need to do that right now. Perhaps we can. This is something that could be handled with a memo or something along those lines. I don't know that we need to take away from your committee discussion time for that. But as I said, a subcommittee. You are a subcommittee, and a subcommittee of 7 means that when you have 4, a quorum is present. If you have less than that, you do not have a legal meeting by definition under RSA 91A.
Since I think we're finished with everything this morning, are you kind of suggesting I don't call him now, or?
I don't know what his schedule is, sir.
Okay, if he's there and available, could you give him a call? And if not, which is more likely, but if he is, we could resolve this presently. Thank you. Anything else, Mr. Clark?
Thank you, Mr. Clerk.
We would be wise, I think, to keep Attorney Cregan posted as to when we meet in case you'd like to show up with or without your French bulldog. If it's my committee, bring the dog. I think would be wise on anything that runs in parallel with 652 to consult with Representative Bernardi. He's done a lot of work on this. That doesn't mean he is co-opted to your subcommittee. He's not, because he's not a member of this committee. But it might be helpful to be in touch with him on certain issues, especially the one about creating an office of family mediation. That might be helpful. So we're looking for black smoke or white smoke from the fourth floor. Habemus disiancia. We have a disiancy.
Yes.
That was not legal Latin, that was ecclesiastical Latin. Okay? Do they speak law French in the Thailand law courts? Un peu? Yes.
So, what is your thoughts on the time frame for which the subcommittees should be doing their work, and then at what point do we want to get back together, or do you want us to get back together as a group to share what they've done?
I'm thinking, just throw it out, the third week of September would be a good time to have subcommittees report back.
Okay.
Each subcommittee would make its report, and we would, in the time that we've set aside, review, ask questions, come towards polishing that report, or simply saying, this is a informal partway report, and we need to go back and do more, and we may add a member, whatever, but I would suggest the third week of September.
All right.
Remembering that there'll be no mileage paid, I believe it's July.
So those of you in the same jurisdiction,
July. June,
walk
July.
back and forth. Yeah.
So just remember that if you're going to be putting in for mileage for your subs.
Except for July. July is for
June,
free.
July.
We'll have to,
Once session ends in June, if we're still here then, and then the whole month of July. So if you don't care about mileage, so be it.
So wait, now I'm confused again. So you can get mileage in July, but not August, or vice versa?
No
Nothing after.
July, no June.
Got it. So all of our travels are gratis.
And I would suggest you contact your leadership office to be sure that mileage will be paid at any particular time in August.
Okay. Thank you for that update. You know, I never bill for mileage for the DCY advisory board either. Like, not once have I thought to do that. And someone was like, you can do that. And I was like, oh.
You know what? I consistently forget.
Right.
okay, black smoke, habemus disiancium non. So
I don't
we'll be in touch. That's
understand that.
that's
What?
Latin. We do not have the disiancy. He's in a meeting. Black smoke. The Pope. Okay, got that? Yeah, okay. So we'll find out and get back to you if there's any disagreements on that. The clerk didn't seem to think so, but we'll get legal counsel on that. And with that, we are adjourned. and see you in September. Well, that went well. That went very well. Approach.